5 seconds to go. Start. Section 198 of the Code of Criminal Procedure 1898, as it originally stood in the Code of Criminal Procedure 1898, read as follows. No court shall take cognizance of an offence falling under Chapter 19 or Chapter 21 of the Indian Penal Code or under Sections 493 to 496, both inclusive of the same code, except upon a complaint made by some person aggrieved by such offence. By Criminal Procedure Second Amendment Act 1943, a proviso was added to Section 198 to the following effect: provided that where the person so aggrieved is a woman who, according to the customs and manners of the country, ought not to be compelled to appear in public, or where such person is under the age of 18 years, or is an idiot or lunatic, or is from sickness or infirmity unable to make a complaint, some other person may, with the leave of the court, make a complaint on his or her behalf. After India attained independence, suggestions were made for the appointment of a law commission for examining the central acts. Initially, a resolution was moved in the Constituent Assembly on December 2, 1947, recommending the establishment of a statutory law revision committee. However, the resolution was withdrawn upon an assurance given by the then Law Minister Dr. Ambedkar to constitute a permanent law commission to revise and codify the laws. Eventually, the Lok Sabha resolved on November 19, 1954 to constitute a law commission to recommend revision and modernization of laws, both substantive and procedural, and in particular the civil and criminal procedure codes. Pursuant thereto, the Law Commission was constituted in August-September 1955 with M.C. Setalwad, Attorney General of India, as its chairman. In the meantime, the Parliament enacted the Code of Criminal Procedure Amendment Act 1955, Act 26 of 1955, which received the assent of the President on 10th August 1955 and was published in the Gazette of India on 12th August 1955. By Section 25 of this Amendment Act 26 of 1955, a new provision in Section 198B was inserted, providing for a special procedure for prosecution for defamation against public servants in respect of their conduct in the discharge of public functions. This Section 198B read as follows. Notwithstanding anything contained in this code, when any offence falling under Chapter 21 of the Indian Penal Code, Act 45 of 1860, other than the offence of defamation by spoken words, is alleged to have been committed against the President or the Vice President or the Governor or Raj Pramukh of a state or a minister or any other public servant employed in connection with the affairs of the Union or of a state in respect of his conduct in the discharge of his public functions, a court of session may take cognizance of such offence without the accused being committed to it for trial upon a complaint in writing made by the public prosecutor. Every such complaint shall set forth the facts which constitute the offence alleged, the nature of such offence, and such other particulars as are reasonably sufficient to give notice to the accused of the offence alleged to have been committed by him. No complaint under subsection 1 shall be made by the public prosecutor except with the previous sanction in the case of the President or the Vice President or the Governor or Raj Pramukh of a state of any secretary to the government authorized by him in this behalf. In the case of a minister of the central government or of a state government, of the secretary to the council of ministers, if any, or of any secretary to the government authorized in this behalf by the government concerned. In the case of any other public servant employed in connection with the affairs of the Union or of a state of the government concerned, no court of session shall take cognizance of an offence under subsection 1 unless the complaint is made within 6 months from the date on which the offence is alleged to have been committed. When the Court of Session takes cognizance of an offence under subsection 1, then, notwithstanding anything contained in this code, the Court of Session shall try the case without a jury, and in trying the case shall follow the procedure prescribed for the trial by magistrates of warrant cases instituted otherwise than on a police report, and the person against whom the offence is alleged to have been committed shall, unless the Court of Session, for reasons to be recorded otherwise directs, be examined as a witness for the prosecution. Stop.